Funding for the Maddie Report is made possible by grants from the California Emerging Technology Fund, leaders in the quest for digital equity. The James Irvine Foundation, committed to a California where all low-income workers have the power to advance economically. Fresno State Associated Students, Inc., students serving students. BNSF Railway, moving our economy for 160 years. And The Wonderful Company. The Maddie Report is also made possible thanks to contributions from Harris Ranch Inn and Restaurant and E&J Gallo Winery. From the Maddie Institute, the Public Policy Institute for the Valley's 4 public universities, this is the Maddie Report with Executive Director of the Maddie Institute, Mark Kepler.
Welcome. When we think about state government, we often think about the California state legislature or the California governor. Often forgotten in the conversation is a third branch of government, the courts, generally, and more specifically, the California Supreme Court. As the state's highest court, its decisions are binding on all other California state courts. In short, the 7 members of the California Supreme Court render decisions that really can change California's lives in fundamental ways. What are their rulings this year, and what are some of the key statistics going on with the court in this most recent term? Our guest is David Carrillo, the Executive Director of the California Constitution Center at UC Berkeley's School of Law. Welcome to the Maddie Report.
Thank you for having me.
So David, let me ask you, how active was the court this term, and how does it compare to the previous terms or previous years? Probably the right way to say it.
I think, if anything, the court was more active this year than it has been in previous years because of the pandemic. But one of the key metrics for outsiders who try to gauge the court's performance year to year, it's somewhat deceptive as a result of the pandemic. So one of the most obvious ways that you can gauge the court's work is how many opinions they release each year. And on average, each year they release about 80 opinions annually. This year they've only issued 49 so far. It says as of October 31st, and that's off pace to reach 80. So if you just took that one number, you could get the impression that either something was wrong or the court just wasn't working that hard or something like that. And I think that would be wrong to get that impression. As a result of the pandemic, if anything, the court was working even harder. But because of the pandemic, I think that obviously impacted their workflow and the speed at which they're issuing decisions. And the other fact that you have to consider is the fact that one of their seats switched around the turn of the year. Justice Chin retired at the end of 2020, and Justice Jenkins took his seat around December or January 2021. There's always a lag time anytime a new justice arrives at the chambers. There are cases on the desk that are in various states of preparation, but it takes a while for a justice to sort of settle into the groove and pick up the work.
Yes, like anyone doing a new job, they've got to get up to speed for a while. By the way, how many clerks work for each justice of the California Supreme Court?
Oh, it varies chambers to chambers. So I think the associate justices all have, I want to say 5 or 6 slots.
Because they've got to also hire those. They've got to hire their clerks, and I would think it would take this time to get up to speed.
Yeah, that also varies significantly. The clerks, they're the staff attorneys, as they're called. They're not clerks. So one of the big differences between the U.S. Supreme Court and the California Supreme Court is that in general, the California Supreme Court does not use term clerks like the U.S. Supreme Court.
Okay.
Does. Yeah, they have semi-permanent staff attorneys, they're called. Okay. I say semi-permanent because they don't have civil service protection. And so I've heard some of the staff attorneys describe their positions being at whim, not at will.
So, yeah, the worst of all worlds. They get to work really hard, but they have really no protections, no employment protections.
Yeah, and so it can happen that when a new justice comes into a chambers, they can clean house and bring in all their new people. That's typically not the case, especially initially, that I would think that'd be very disruptive to say, okay, you're all fired. I'm bringing in my
and that would really slow things down. Obviously.
Yeah, that would make it worse. Yeah.
When we were talking, we were talking before when we were organizing the program, and you mentioned something about the People v. Martinez decision, that it made a decision, quote, on its own motion, unquote. I had never heard of that before. Can you explain to our audience what that's all about?
Yeah, the California Supreme Court it's not a court of error correction. It doesn't sit to rule on every mistake that happens at the lower courts when they do happen. It's a court of primarily discretionary review. It has a few things that it's required to review, capital appeals being the best and most obvious example. But other than those original jurisdiction automatic appeal type things, the court's docket is primarily at its own discretion, and the rules of court and the nature of it being a court of discretionary review, it has the power to decide what cases are significant enough to warrant its attention. It's not out there, sort of riding the range looking for problems, but when they present themselves, it's the court's job to resolve them. So one of the ways that it can do that, it has a bunch of procedural vehicles. It can take review in a case, they can deny review in a case, they can grant and hold it to see if something in another case affects it. They can transfer it down.
Somebody issue to kind of come ripe, in other words.
That can happen, or there might already be a couple of cases on the stove that present a similar issue, and so your case is, the third in that series, and so it gets granted and held to get decided along with the other two cases that are already cooking. And an own motion grant is kind of a similar procedural vehicle for the court to manage its own docket. So if in an instance where even if the parties to the case don't request the court review it, if the court, with this kind of global view of what's going on in California appellate world, they might see something that the parties aren't necessarily aware of, and so the court can order review on its own motion.
Okay. Well, up next, we're going to talk about this recent turnover in the California Supreme Court and what that may mean for California jurisprudence going forward. That conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Kepler with the Maddy Institute. We're speaking with David Carrillo, the Executive Director of the California Constitution Center at UC Berkeley's School of Law, about what happened in the California Supreme Court over the last year. Now, one of the bigger issues or concerns, I guess, is who is sitting on the California Supreme Court. We spoke earlier about the lower number of decisions that the California Supreme Court had this year. Justice Cuellar is stepping down. How much will his departure impact productivity?
Well, he has in fact already left the court. His last day was about a week or so ago. He left at the end of October. So you're looking at a transition period. You have Justice Jenkins, who's now getting up to speed. He's published his first couple of majority opinions, so he's probably good to go. But now you have another empty seat, so we'll be looking for Governor Newsom to fill it. The good news is that whereas Governor Brown did not move particularly quickly, filling seats on the California Supreme Court. With the first pick that he's had so far, replacing Justice Chin, Governor Newsom acted quite quickly. And with the November elections behind us and the recall behind us, I'd be surprised if Governor Newsom waited very long at all before filling Justice Cuellar's seat.
Yeah, it's interesting that the California Supreme Court Chief Justice has got not just sitting on the court running decisions, but she also had a lot of administrative duties. But what you've indicated is that she's been pretty prolific this year, given all the other work she has. That's not normal, is it?
No, I mean, if anything, so in addition to being the Chief Justice and having administrative responsibilities at the court itself, more broadly, the Chief Justice is also the head of the Judicial Council, which runs the entire judicial branch of California, all the courts of appeal, all 58 county superior courts. It's the third branch of California's government, so it's a whole branch of the state government. So she has to run that in addition to running the California Supreme Court, in addition to writing the opinions that she assigns to her own chambers. So with all of that additional responsibility, it's understandable that the Chief Justice is typically not the opinion writing leader among the 7 justices. But this year, so far, she actually is. She's in the lead with 10 majority opinions. So in a pandemic year, when her administrative responsibilities are probably tripled and she's leading with the most opinions out of all the justices, it's frankly amazing. She's really earned her pay.
Yeah, for sure. You were talking about Justice Cuellar, and I guess the analogy is an old track. I would say he basically ran through the tape. I mean, he really was productive in his last year.
Yeah, it's amazing. So, for people like me who count California Supreme Court opinions, the perennial leaders in that metric were Justice Chin and Justice Liu. Justice Cuellar was typically not in that group, but now here in his last year, he's second, right behind the Chief Justice for second most opinions, majority opinions in his last year. And he wrote what's probably the banner standout case for this year, which was In re Humphrey. So he's going out strong. He's probably going to close with around 70 to 75 career majority opinions, which is a pretty solid record.
Yeah, that's amazing. Justice Jenkins was confirmed by as Associate Justice of the Supreme Court back last year at the end of 2020. He's relatively new to the court, as we've noted. The governor is also going to be able to appoint another justice of the Supreme Court to take Justice Cuellar's place. I'm just wondering, with these two new justices, how much is that going to change the court?
I think there's two ways to look at Justice Jenkins, and I'll talk about replacing Justice Cuellar in a second. Justice Jenkins is somebody that you could either say you know a lot about him or you don't know very much about him at all. He's been on the bench in various courts for many years. So from that perspective, he has a very long judicial track record. He's very well known, very well respected, up until this point now that he's gotten on the California Supreme Court. So as far as his track record goes, we know a lot about Justice Jenkins. The one thing that we don't know, or the way in which we don't know him very well, is how he's going to behave on the California Supreme Court. We have a very limited set of votes from this year. There's only been 49 opinions. We only have 2 majority opinions from Justice Jenkins. So I think it's too early to say how he's going to fit into the court's voting pattern. But that said, it would take a pretty substantial reorientation of the court's voting pattern for it to bring it into the kind of discussion that people typically have about the U.S. Supreme Court with a conservative bloc and a liberal bloc. California Supreme Court's just not organized like that. I've been looking for evidence of that in the last 5 to 10 years. I don't see it. And if Justice Jenkins is the person who changes that dynamic, that would be moving the Titanic. I'd be pretty surprised by that.
Yeah, you were saying earlier that the court has been a lot of 7-0 decisions. It's not like a 4-3, or we have this conservative liberal 6-3 split on the U.S. Supreme Court. California Supreme Court has been pretty unanimous. Some might say that because they're all appointed by Democratic governors.
There is that perspective. It is true that our court's unanimity rate is in the 90th percentile, whereas U.S. Supreme Court is a lot lower than that, pretty consistently for both courts. Chief Justice was appointed by Governor Schwarzenegger. If I remember correctly, Justice Corrigan was appointed by, I want to say, Pete Wilson. Justice Chin was also a Republican governor appointment.
So it's just a different. The California Supreme Court's not like the U.S. Supreme Court in that regard.
No, not at all. So so my point is, so even when you had on paper a 4-3 split with 4 justices being appointed by a Democratic governor, Jerry Brown, and then the other 3 being appointed by Republican governors in the past, I looked for evidence of a 4-3 liberal conservative split, and on a fairly large data set, I couldn't find it.
Well, we're going to pick up on that in a second. We're coming against a hard deadline. That's a really interesting point. Up next, we're going to talk about some of the cases the court was hearing over the last year. That conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Kepler with the Maddy Institute. We're talking with David Carrillo, the Executive Director of the California Constitution Center at UC Berkeley School of Law, about what happened over the last year on the California Supreme Court. So, David, I want to ask you about, the court deals with a full panoply of issues. I'm just wondering what area of law had the most attention of the court, and is that normal? Or whatever that area was, is that normal?
Well, I think one of the interesting things about this year's docket is that we're in the second year of the pandemic. So what was interesting about the court's docket is what we didn't see coming out of the court's opinions, which was decisions on the emergency pandemic restrictions. My colleague David Ettinger, who publishes At the Lectern, He helpfully sent me about half a dozen instances of the court refusing to even hear challenges to emergency pandemic restrictions. Those have all been sorted out either at the Ninth Circuit or in the California Court of Appeal. So there have been quite a few challenges to emergency restrictions, and they have been sorted out by the courts, but not by the California Supreme Court. So I thought that was pretty interesting.
Yeah, that is kind of interesting that they did that, because you would think with all the stuff going on at school boards and the rest of it, you'd think that would be something more common the court would be dealing with.
Yeah, I think there's a couple takeaways. One is that the Court of Appeal was getting them right, and two, the court didn't see any of those disputes as being significant enough to warrant its attention. Not that the pandemic wasn't significant, and not that the issues weren't important, but if nothing's going wrong below, but not much for the court to do.
But it's not unusual, because I'm guessing a lot of criminal cases the court was hearing this last year.
Yeah, if anything, that was the thing that was typical about the court's docket, was that it typically does have around a third to a half, sometimes more than a half of its cases concerning criminal cases. That's very common. And that was the case this year. There's 49 merits decisions through the end of October. Crime was the single largest docket segment. Employment was the only other one. So in the criminal segment, there's general crime, and then there's the automatic capital appeals. There were 13 of those, and the other 17 were general crime, and that together
so
that adds up to
13
29.
of the 30. I mean, almost half were capital appeals.
Yeah, that's fairly common. And if you work that out, it's around a third of the court's decisions so far are automatic capital appeals. And if you extrapolate that out to a more normal year where you're getting 80 opinions, that would be typical. Former Chief Justice George used to rail about how much of the court's docket was taken up with the automatic capital appeals. Not that those cases aren't important. It's just that they take up the lion's share of the court's time.
That's really interesting. You did say, though, the other area of law where there were some cases was the area of employment. You had some cases there. How many cases, how significant were those cases?
So when I was looking at it, other than crime and other than employment, everything else sort of fell into a miscellaneous category. Employment really was the only other non-criminal tranche of cases that had any significant numbers. There were, I think there were 8 of them. So you had 8 employment cases, 4 torts, 2 medical, 2 civil procedure, and 4 things that I really couldn't categorize. So they went into a miscellaneous bin.
Yeah, we only have about a minute left in this segment, but I wanted to ask you, that's not a very large number of cases. So there's not a large number of cases that actually make it to the California Supreme Court. Not like they're getting, they appeal the Supreme Court, but the court doesn't necessarily have to hear them.
Right, exactly. It's a court of discretionary review. Year to year, around 3 to 5% of petitions for review get granted by the California Supreme Court, which is vanishingly small odds of getting your case granted review by the California Supreme Court. They really do not sit as a court of error correction. Their criteria are: does the case present a significant issue of law, and is there a dispute among the courts of appeal? Both would be best.
That's a great segue for our next segment, because up next, we're going to talk about some of the key decisions of the California Supreme Court over the last year. That conversation in a moment. Welcome back. I'm Mark Kepler with the Manny Institute. We're talking with David Carrillo, the Executive Director of the California Constitution Center at UC Berkeley School of Law. He's probably a good person to ask this question. What were the key decisions of the Supreme Court this last year? So I suppose a good place to start is, how do you define a key decision?
Yeah, and you phrased it exactly right. In terms of what they've done so far this year, the California Supreme Court does not observe a term schedule like the U.S. Supreme Court does. The U.S. Supreme Court starts its term in October. California Supreme Court works year round. So there's Slicing their cases is always somewhat arbitrary. They tend to issue most of their decisions in a block over the summer because they don't hear oral arguments in July and August. But other than their fiscal year schedule, they issue decisions constantly year round. So we're being a little arbitrary. Part of it's my bias, saying what I think is an important decision. But it's certainly one of the decisions we're about to talk about. I think everybody will agree was a banner decision. Because
we did talk about before we taped this program today, and one of the decisions you mentioned that you thought was really important was Brown versus USA Taekwondo. What would the court decide in that case?
Yeah, it's the facts of the case concern obviously a very serious and fraught issue, and unfortunately, the case did not turn out very well for the plaintiffs. The plaintiffs in this instance were student athletes who were minors and were competing in Olympic sports, and they alleged sexual abuse by their coaches, and they sued the national organization of their sport and the U.S. Olympic Committee. And the question in the case was whether those entities that were so far removed or much more removed than the coach who allegedly committed the conduct, whether those entities bore any tort responsibility for the harms that the student athletes suffered. So it's both a very important and difficult societal issue, and it's also a very important question of tort law. And in Brown versus USA Taekwondo, as I said, it didn't go well for the plaintiffs. So
what you're going to tell me is that they narrowed the field.
Yeah. So the key case here is Rowland versus Christian. And, so there's what the law says about who you have a duty to, but Rowland defined a multi-factor test for, as a policy matter, deciding when a court can expand the field of who can owe a third party duty to a plaintiff. And the reason the California Supreme Court took this case, it seems to me, is because there was a conflict among the courts of appeal about how you're supposed to view the Rowland factors. Are they used to expand or to narrow the field of additional third parties who owe duty? Some courts of appeal have been reading Rowland expansively and using it to include people who are third parties and owe duty. California Supreme Court in Brown said, no, it's actually the other way around. Rowland's factors are used to limit the field of people who owe duty.
I think that's going to surprise people because I think a lot of people would think, the California Supreme Court is a liberal court. They're going to expand it. And in this instance, they didn't. I want to get to another decision. We've only got, there's so many things to talk about. And I want to see if we can quickly talk about prevailing wage cases. There's some public work cases that were important. And then I want to get to the last decision, the Humphrey decision, but we only got about 2 minutes. So quickly, this public works cases, what happened there?
It's a prevailing wage issue. It's 3 cases that were decided roughly as a group. They're all written by Justice Corrigan. They all concern the definition of public works. So if you have a broad definition of public works, that means more people get a prevailing wage. If you have a narrow definition of what constitutes a public work, that means fewer people are entitled to or required to be given a prevailing wage. And the cases present a nuanced view of that. So in one instance, the court read it broadly. In another instance, the court read it narrowly. So all 3 of them read together, they give you a series of examples of when something qualifies as a public work and when it doesn't.
Yeah, and that's really important to cities and school districts in dealing with this issue. We've only got, again, we're covering a lot of ground. We've only got about a minute and a half left, but I know there was a really important decision in Humphrey that you wanted to talk about.
Humphrey is super important. Bail obviously is going to be important to anybody who gets arrested for something. Being able to make bail frequently is the difference between either being able to actually mount a defense or sitting in jail long enough that it makes sense to just plead to it for credit for time served. Not making bail substantially drives up plea conviction rates. So the issue in Humphrey was whether bail is a right and courts should be giving bail liberally regardless of a person's ability to pay, or whether bail is construed fairly narrowly and more people are going to be denied bail. The California Supreme Court read bail, the bail provisions of the California Supreme Court fairly broadly. It did not categorically hold money bail to be unconstitutional. Money bail can still be set, but it has to be set at an amount within a defendant's means. So the key takeaway from Humphrey,
ability to pay is going to be an issue, and that's important in criminal justice. Well, I want to thank our guest, David Carrillo, who is the executive director of the California Constitutional Center at UC Berkeley School of Law. This is Mark Kepler for the Maddy Report. Thank you for joining us. If you want to stay up to date on state and local politics, you can sign up for our free e-newsletter, The Maddy Daily, by logging on to our website at maddyinstitute.org.